Let's go to that executive order by the president, and now the Attorney General has fiercely defended President Uhuru Kenyatta's directive on police recruits, which has been criticized as a defiance of the courts. AG Githu Muigai maintains the president did what he had to do. But as Linda Oguttu reports, the Commission for the Implementation of the Constitution says the president's directive is a violation of the law. Linda also spoke to one of Kenya's top legal minds, who insists that the president had several useful options and did not have to defy the courts.
The outcome of that recruitment is hereby quashed. I will also issue an order prohibiting the Commission from issuing appointment or any other letters to persons recruited on that day on the basis of that exercise.
I also further direct the Inspector General of Police to take urgent steps and ensure that the 10,000 recruits whose enrollment is pending promptly report for training at the Kenya Police College in Kiganjo. I take full responsibility for this directive.
And with that, the battle of separation of powers between the executive and the judiciary unfolded. The president, under immense pressure to protect the people of his nation, and a judicial ruling that, according to him, has seen Kenyans continue to suffer from terror attacks that would be prevented if only there were enough police officers. The Commander-in-Chief may have meant well. Legal minds, however, say his directive is against the law. He may be the head of state, but he is not above the law.
He assumes power pursuant to the procedure set by law. So how can he be above that very mechanism that sets out the mechanisms through which he assumes power?
The president's directive goes against the rule of law, which in its most basic form is a principle that no one is above the law. The most important application of the rule of law is the principle that governmental authority is legitimately exercised only in accordance with written, publicly disclosed laws adopted and enforced in accordance with established procedural steps that are referred to as due process. The principle is intended to be a safeguard against arbitrary governance.
Part of the indicators of the rule of law in a society is that courts function independently without fear of reprimand, and number two, court orders are complied with. Now, in a society like ours, where court orders are not complied with, we suffer what we call a democracy deficit. We are doing very badly.
Legal minds say there needs to be congruence between official action and the law. When powerful public officials like the president overrule court decisions, then the long-term effect may render court decisions and indeed the judiciary irrelevant. The consequences could be dire.
You therefore don't know how far he can go with this power. That's very dangerous. Today, the Inspector General of Police is perhaps preparing to act in accordance with a presidential directive contrary to a court order. That means a precedent has been set. Tomorrow he can take another directive from the president. Think about yourselves at Media House, for example. What if the Inspector General of reading you and saying, I was ordered by the president? Now you have no limits. You now can act as directed by the president, which means arbitrary, which means whimsically. And that, I must concede, is extremely dangerous for any democracy known in the world of democracies.
Attorney General Githu Muigai has faulted the court for nullifying the entire police recruitment process, saying nullification should have been done in areas where irregularities have been reported. Legal minds disagree.
The Attorney General knows better than I do that the proper remedy is going back to the same court for review of that order, or going to a higher court on appeal, which I understand is what has happened. Now, when you are on appeal, you must submit to the court process. You can't at first go to the court process to plead with the court to give you an order one or the other. Then outside court, you act as if you are dictating to court to act one way. That way, I mean, the Attorney General is eating at the very roots of the rule of law and constitutionalism as I know it. We are now in another year where the President is perfectly in order to order a new police recruitment, even as we sort out the issues surrounding that old police recruitment. And therefore, if the President went to Parliament with a supplementary budget to seek that he gets a budget to conduct a fresh police recruitment, I don't think that would have been impossible. Number two, there is a process of certification of urgency of matters. You and I know that when media houses were unhappy with the conduct of the Communication Authority of Kenya, they got a matter to move from the High Court to the Court of Appeal to the Supreme Court in less than 1 year. And that therefore means that once a court is appropriately moved to certify a particular matter urgent, the court can do so. The president, using his legal advisors, legal representatives of the government, would have still persuaded the president of the Court of Appeal to certify the pending appeal as urgent and gave it a priority date for hearing. All these are lawful options that were available to the president, which the president never even attempted to pursue.
So help me God.
And so, legally, it is hoped that the pressure to win the war on terror will not push the head of state to undermine the decision of one of the three arms of government that is recognized by the very constitution he swore to protect. Linda Oguttu, KTN.